Greetings to all. I am Mithun Balaji from BCom F&A Section B. I am here to present my Law CAA case studies. The first case I am going to take is Vedanta versus the Union of India. Introduction. The case explains the event that led to the closure of the Sterlite plant in Thoothukudi in Indian state of Tamil Nadu. The massive protest by anti-Sterlite activists against the alleged environmental hazards caused by the Sterlite plant culminated in the death of 10 people in the police firing and eventually led to Tamil Nadu state government shutting down the Sterlite plant. The case highlights a floatering of the environmental rules and regulations by the Sterlite. The impact of the environmental pollution caused by the Sterlite plant on the air, water and land is explained with the help of various reports and studies conducted by the environmental agencies. The views and options of the general public, industrial observers and business analysts and the environmental agencies are presented in the case. The case also points out the fact that Sterlite was contributing to the development of the areas by generating employment opportunities and providing a livelihood to thousands of people. Sterlite was catering to 36% of the domestic copper requirements of the country. There were scores of local and allied industrial dependence on the copper produced by Sterlite. The impact of the closure of the plant on the development of the area and allied industries is also discussed. On May 22, 2018, Sterlite Copper, the copper manufacturing plant of Vedanta Limited in Thoothukudi in Indian state of Tamil Nadu was shaken by a massive protest. The protesters who maintained the copper plant was polluting the environment were livid over the proposed expansion of the plant's second unit, which was expected to double the production capacity per year. Massive gathering of 2,000 protesters for the accumulation of 100 days of the protest against the proposed expansion. The local administration took various steps like imposing Section 144 on the Code of Criminal Procedures prohibiting the assembly of people in and around the plant. But the restless crowd turned violent and damaged the public property. In police firing which followed, 10 persons were killed and many others were injured. In favor of plant closure. The Sterlite seemed to have violated the basic conditions that hazardous industries were not allowed to locate near the habitation of the dense human population. Thoothukudi, with a population of 5 lakh, was the 10th most populated city in Tamil Nadu. The Environmental Protection Act of 1986 specified areas where any industry was restricted from establishing and carrying out operations against the plant's closure. Many residents who worked in the plant and had relatives working there was in favor of being reopened, since their livelihood majorly depended on that plant's judgment. The Madras High Court dismissed Vedanta's pleas challenging the closure of its Sterlite copper smelter plant in Thoothukudi. On February 27, 2019, Vedanta approached the High Court seeking the reopening of Sterlite, which was closed in the view of order passed by the Tamil Nadu Pollution Control Board (TNPC) dated on May 23, 2018 to fight the battle against COVID-19, which was allowed by the central government. Case study number 2. Dewan Housing Finance Corporation Limited versus SEBI. Before math. According to Section 14 of the Insolvency and Bankruptcy Code of 2016 and the National Company Law Tribunal, on the insolvency commencement date by the order shall be required to declare a memorandum prohibiting the institute of suits and continuation of pending suits or proceeding against the corporate body, include the execution of judgment or order in any court of law, tribunal, arbitrary panel or other authority. This issue gained prominence in the case of Dewan Housing Finance Corporation Limited versus SEBI, where the issue of consideration before securities Appellate Tribunal (SAT) constituted of whether SEBI can initiate or continue the proceedings of violation of securities law against a corporate debtor. This article aims to provide an analysis of the case through the exploration of the question concerning issue whether SEBI has jurisdiction to initiate proceedings against the company when the memorandum is imposed under Section 14 of IBC. Facts: the Reserve Bank of India suspended the board of directors of DHFL under the Section 14 IE of Reserve Bank of India 1934 and appointed an administrator to manage the affairs of the company. Subsequently, RBI also filed an application under Rule 5A1 of Insolvency and Bankruptcy Rules 2019 before NCLT to initiate incorporate resolution insolvency process against DHFL. The application was admitted and the memorandum was ordered under Section 14 of IBC. After commencement of CIRP, the adjusting officer of SEBI issued to show cause the notice to DHFL under Rule 4 of Securities Exchange Board of India. To show the cause why penalty should not be imposed for a non-compliance of provision of Regulations 16 of Securities Exchange Board of India. SEBI in the SCN alleged that DHFL had failed to create a request debenture redemption reserve and failed to invest 15% of the amount of non-convertible debentures under listing regulations that were maturing on 31st March 2020. DHFL has also failed to submit the audited financial and line items as prescribed by law regulations. In reply of SCN filed by DHFL, it was stated that since the company is undergoing CIRP in the view of Section 14 of IBC, no proceedings can be instituted or continued against the company in the currency period of moratorium. Pending consideration, the adjudicating officers of SEBI imposed a penalty of INR 20 lakhs on DHFL and held that Section 14 of IBC does not prevent such adjusting officers from determining the liability of corporate debtors. The memorandum merely prohibits recovery enforcement proceedings, but the proceeding is an instant matter and concerned with determining the liability of the corporate debentures for non-compliance with securities regulation and securities law. Subsequently, an appeal was filed by DHFL before SAT against the order of adjudicating officers of SEBI. Issue: whether SEBI has jurisdiction to initiate proceedings against the company when a memorandum is imposed under Section 14 of IBC. Judgment: the order passed by SEBI adjudicating officer referred to the observation made by the Insolvency Law Committee report of 2018 that proceedings initiated to determine or assess the liability is different from recovery, assessed or determined liability. The moratorium imposed on proceeding to determine liability may not have been an intent of IBC. The SAT held that adjudicating officer should not have referred the Insolvency Committee report of 2018 since external aids for interpretation should be only considered in situations of ambiguity. It was further held that once the memorandum is imposed under Section 14 of IBC, the adjudicating officer will not have the jurisdiction to institute proceedings. Therefore, the order of SEBI adjudicating officer proceedings of recovery under Section 28A upon failure to pay SCN and squashed, as the proceedings cannot institute after the moratorium is imposed under Section 14 of IBC. Conclusion: it can be concluded from the above analysis that SAT has rightly held SEBI and cannot initiate proceedings against the company after the moratorium is imposed under Section 14 of IBC. The decision of SAT will help to preserve the assets of the corporate debtors and allow the available resources to be utilized efficiently for complete repayment. Thank you.